Case number 116190 in the matter of Michael Jardine.
Good morning, Penny Moylan appearing on behalf of the Kansas Disciplinary Administrator's Office. Chief Justice Nuss, I would like to request 2 minutes for rebuttal time. 2
minutes is granted.
This is an original action in discipline, and by way of short summary, in July of 2014, the respondent was campaigning for a district judge position in the 16th Judicial District of Kansas. A couple weeks before the August primary election, a reporter contacted the respondent about an outstanding 2005 arrest warrant in Michigan for the possession of marijuana. The respondent was unaware of this outstanding arrest warrant, and after confirming it, he reported the information to our office. He traveled to Michigan and ended up pleading guilty to disorderly conduct in exchange for having that arrest warrant for the possession of marijuana dismissed. The misconduct at issue in this case occurred not because of the 2005 incident, but as a result of the respondent's subsequent misrepresentations to the public that he was not the individual stopped during the 2005 Michigan incident. This office charged respondent with a violation of 8.2b, which provides the lawyers of a candidate for judicial office shall comply with the applicable provisions of the Code of Judicial Conduct. We also charged him with a violation of 8.4c. The respondent stipulated to the facts contained in the complaint as well as the 2 rule violations. Although the complaint did not charge respondent with a violation of any specific Code of Judicial Conduct, when discussing 8.2b at the hearing, I informed the panel that, for the record, the applicable provision of the Code of Judicial Conduct is 4.184, which provides that a judicial candidate shall not knowingly or with reckless disregard for the truth make any false or misleading statement. In its conclusions of law, the hearing panel found that based upon the respondent's stipulations and its finding of fact, the respondent violated 8.2, 8.4, and Rule 4.184 of the Kansas Code of Judicial Conduct. I believe that the hearing panel's conclusion of law prompted this court to issue its order last Thursday requesting oral argument on the 3 issues. And I can recite the issues for the court, but what I'd like to do at this point in time is divide my oral argument into 2 parts. And the first is to address the issues raised in the court's order, and the second to address the appropriate discipline. I've talked to Mr. Ambrosio, counsel for the respondent, prior to the hearing, and we're both in agreement that we're going to take the position that the Kansas Board of Discipline of Attorneys and the Kansas Commission on Judicial Qualifications have concurrent jurisdiction over the alleged violations of Canon 4 of the Kansas Code of Judicial Conduct when the respondent is an attorney acting as a judicial candidate. We would argue that in this particular case, when the attorney who is campaigning for a judicial position does not actually get that position, that the appropriate forum is the Kansas Board of Discipline. And I have various reasons for that argument. The first of all is just on the notion of concurrent jurisdiction. As this court is aware, it exists when 2 separate courts, but in this case, I'm going to talk about the Board of Discipline for Attorneys or the Commission on Judicial Qualifications. They have jurisdiction over the subject matter if either place is a proper forum for its resolution. As you all know, subject matter jurisdiction is vested by statute. In this particular case, we're going to say it's vested by particular Supreme Court rules. First of all, Rule 201A provides that any attorney admitted to practice law in this state is subject to the jurisdiction of the Supreme Court and the authority established by the rules relating to the discipline of attorneys. Rule 202 provides that any acts by attorneys that violate the disciplinary rules of the Supreme Court shall constitute misconduct and shall be grounds for discipline, regardless of whether the acts occurred during the course of an attorney-client relationship. Then a specific issue here is Rule 8.2b, which I already said provides that a lawyer who is a candidate for judicial office shall comply with the applicable provisions of the Code of Judicial Conduct. And comment 2 to that rule provides that when a lawyer seeks judicial office, the lawyer should be bound by the applicable limitations on political activity. Both the rule and the comment are identical to the model rule, and the commentary on the ABA model rule annotations provides, and this is a quote, "Lawyers who are candidates for judicial office are subject to discipline under Rule 8.2b of the Lawyer Ethics Rules for violating applicable judicial ethics rules." Comment 2 specifically invokes the Judicial Code's limitations on political activity. And indeed, Canon 4 of the 2007 ABA Model Code of Judicial Conduct is the only canon that specifically regulates canons as well as sitting judges. Therefore, we would argue that because the board is vested with jurisdiction to determine whether an attorney complies with the Kansas Rules of Professional Conduct, and KRPC 8.2 provides that lawyers who is a judicial candidate shall comply with the applicable Code of Judicial Conduct, the Board of Attorney Discipline has jurisdiction to determine whether or not they violate that provision. And I want to go now to the Judicial Code of Conduct and talk about Canon 5 that no longer exists, and I think it kind of supports our position. The previous Canon 5 that was replaced in, I think, 2007 said, Canon 5 generally applies to all incumbent judges and judicial candidates. A successful candidate, whether or not an incumbent, is subject to judicial discipline for his or her campaign conduct. An unsuccessful candidate who is a lawyer is subject to lawyer discipline for his or her campaign conduct. A lawyer as a candidate for judicial office is subject to Rule 8.2 of the ABA Model Rules of Professional Conduct. And so what that tells me is that in cases of an attorney who is running for a judicial office, if they commit conduct during that judicial campaign, they're within the jurisdiction of the Board of Discipline of Attorneys based on 8.2b. If they were to commit that misconduct and then become a judge, that would have taken them out of the purview of the Board of Discipline's jurisdiction, because now they're a judge, and so judicial qual would come into play. So it's our position that 8.2b addresses that situation where an attorney who is campaigning commits misconduct according to the canons and then does not become a judge, which is what we have in this particular case. We would also argue to the converse of that. For example, prior to the model rules for judicial conduct or the Kansas rules for judicial conduct contemplating a judicial candidate, suppose a lawyer has a judicial campaign, they commit misconduct during that campaign, they subsequently are successful and become a judge, then prior to the code providing for judicial candidates, the code wouldn't have any jurisdiction over that now judge's conduct as an attorney. Does that make sense? So it's our position in this case that 8.2b provides the Board of Discipline with jurisdiction for attorneys that are running for a judicial campaign and that commit a violation of the canon and then do not become a judge. If Mr. Jardine had been successful in his campaign and was now a sitting district court judge, I don't believe our office would have handled this matter. It would have gone to judicial qualification. Is there any question on that? Okay, then I'm going to go on to the second part of my argument this morning, which is the appropriate discipline. As I mentioned before, the panel, Mr. Jardine stipulated to the rules violations and to the facts. The panel, our office recommended 1-year suspension. Mr. Jardine requested published censure, and the panel actually recommended published censure. Our office stands by its recommendation of 1-year suspension. As I made the argument before the hearing panel, we believe that this is very serious conduct. You have an attorney that's running to become a judicial district judge and misrepresented the truth, not on one occasion, but on 3 separate occasions. And I think the panel sort of found as a mitigating factor the fact that Mr. Jardine was inexperienced in politics. And we would argue that that's not a mitigating factor. Mr. Jardine, it wasn't a case of someone ambushing him and asking him a question, and he panicked and responded. But the misconduct occurred after he'd had some time to think about it, and occurred on 3 separate occasions. One time when he called back a reporter and he said, "I was not the person at issue in this 2005 incident." The second time was at a judicial candidate forum, and again made the same misrepresentation. And the third time was when Mr. Jardine actually sat down and responded to an online forum and took the time, to think it out, and again repeated the lie. It was our position that it was done for a selfish motive, that he wanted to win the election, and made those misrepresentations based upon that. There was a duty owed to the public. Again, we argued that this is a very serious duty to maintain the highest form of integrity when you're running to become a judge, and that's why the harm was especially egregious in this case. Mr. Jardine's mental state was intentional. He made a conscious, objective decision to accomplish a particular result. And as I talked about, the injury is on the public, the legal system, and the profession. So we would stand behind our recommendation of the year suspension. Are there any questions?
That would be effective as of the date of the decision that's released.
Correct.
Any further questions? Thank you, counsel.
John Ambrosio on behalf of the respondent. May it please the court, Mr. Chief Justice. My colleague and I did visit about this on the phone after we received your order, and we visited again by phone Saturday and yesterday, and I'm in agreement in her argument about the applicable law in this case. The most important thing to be decided in this case is what discipline is to be meted out. My client agreed to the facts. He stipulated to the rules violations. He knows this was serious, and he knows it was wrong. He made a misrepresentation to the paper, misrepresentation at a forum. The panel report at paragraph 40 says it all, and I cite you to that. Because of the presence of the persuasive mitigating factors in the hearing, in panel's opinion, suspension is not warranted. The respondent was inexperienced in politics and running for election. While the respondent's dishonest reaction to the political pressure is unacceptable, and they're right about that, it appears that it was the result of youthful pride. It also appears that the respondent has learned important lessons from this experience and that the underlying circumstances are unlikely to repeat. I don't know what goes on anybody's mind when they run for election, for anything, especially when you run for a judicial office. So I can't put myself in his position. All I can tell you is that the panel gleaned from his testimony that he was inexperienced, that he made a mistake, and it was because he was prideful. They told him he was wrong, he told them he was wrong, and he will accept whatever you mete out. He has been in utter agony since this has occurred. And you have to look at the context of how he got in this type of trouble. He's a practicing lawyer, he's an assistant county attorney, and people want him to run for judicial office, for district court judge. And he decides to do it. Unbeknownst to him, the case that he thought he left behind that was never filed, the marijuana case, was filed without his knowledge almost a year after he left that jurisdiction. He worked as a Wyandotte intern in district attorney's office. They did a background check, nothing showed up. Did a background check when he applied for the bar, nothing showed up. Nothing showed up until a private investigator and the paper somehow found out about what occurred in Michigan. Then he got scared. If he had stood up to the plate and should have said, hey, yeah, I had marijuana and I was wrong. And I understand that I'm going to be sentencing people for marijuana convictions, that in this state it's against the law, although I don't think it should be. He could have said, I understand I have an obligation to follow the law, and I had an obligation to follow the law back then. He didn't do that. He made a big mistake. To suspend him for a year for that type of mistake, I believe is dead wrong. He has learned and he has been chastised in the press, before the hearing panel, and now before this court. Everybody in Dodge City and Cimarron knows about it, in that area. They all know about it. It has hurt his practice. I'm sure it's going to hurt him as a county attorney, and God knows he's never going to run for office again. He's in that town. He's trying to earn a living. He's trying to make reparation for what he did. Without any further ado, my client would like to address you on these issues. With your permission, sir.
May it please the court. Justices, I'm here today to express my apologies and my sincerest regret for my actions and my conduct involved in the 2014 16th Judicial District elections. Looking back on that election, I view it as the biggest mistake of my life, and I live through that regret each and every day. I was surprised at the time I ran for office to know that there was a warrant outstanding for me in the state of Michigan. I relied on the advice of an attorney and attorney admissions in the state of Kansas that there was no such incident in my past that would come up in the course of the election. Upon discovering that, I think it's important for this court to know that I self-reported. I cooperated fully at every step of this process, and I stand in front of the court willing to accept any punishment that the court metes out. In the 8 years prior to running for election, I practiced with distinction, without incident or allegation. In the 2 years since this incident, I practiced with distinction, without incident or allegation. I covered 2 full-time caseloads when my managing partner went through a bout of cancer, required treatment that left him out of the office for a year, as well as carrying a county attorney workload in Gray County, Kansas. This is a one-off experience that has no possibility or capability of repeating itself. If I'm allowed to continue practicing law, I will continue to practice with distinction, without incident or allegation.
When you said that you relied on assurances from who? From the Kansas Bar Examiners? That this would, who did you rely on assurances that this would not?
An attorney in the state of Michigan, as well as my full disclosure to attorney admissions and character and fitness.
So you're basing it on that when you applied for Kansas Bar, that there was nothing in your background that would come up?
Correct.
Okay.
Wait, and when you say that, counsel, you mean that you disclosed this incident where you were stopped, or you did not disclose it because you didn't think it resulted in any legal action? Okay, thank you.
He hired counsel there, and the lawyer in Michigan indicated to him that there were no charges.
And when this happened, there's been much made about the fact that you were a candidate for a judicial position, but you were also at that time a prosecutor, a county attorney. And so how do you think we should view that you were in a position of immense power, as prosecutors are, and you didn't display the utmost candor?
Well, I would ask the court to view it as a position of service rather than a position of great power. And I would ask the court to rely on my practice in the prior 8 years and the 2 years since then to show that this is a one-off experience, never misrepresented a fact or an event in court to counsel or portrayed facts as anything other than exactly what they are in the courtroom and in my practice with the other attorneys in my district.
Do we have any further presentation from either of you?
We do not.
I have one question, if I may, for Mr. Ambrosio. And this question may appear to come out of left field, and so I apologize in advance for that. And it has to do with something neither party has raised, but it's just simply this. Do you have any concern at all or thoughts with respect to First Amendment issues or Section 11 of the Kansas Bill of Rights issues with regard to these limitations on speech?
I do not. It's not really out of left field. It's kind of out of the ballpark, but I accept that, Your Honor. I do not.
If you did, you would raise those
I
issues.
certainly would.
Okay.
It's not a Gentile event or Gentile event, which was the lawyer who got in trouble in Las Vegas because of that.
Any more questions? No further presentation. Thank you.
Thank you.
You reserve 2 minutes for rebuttal.
Thank you. Just briefly, unless the court has some questions, I'm sympathetic to Mr. Jardine's situation. He did make a mistake, and I have no doubt that he was under a great deal of stress during the campaign. But as mentioned by Justice Johnson, he was also occupying a position as a county attorney at the time. He was also a part-time municipal judge. And so this duty of being honest and above reproach and showing restraint, all of those things are very important. And while published censure is discipline, I'm not sure what kind of message that sends to the public when we have someone in this position that has made a conscious decision on 3 separate occasions to misrepresent the truth over something that did appear to be innocuous, but nevertheless goes to the character of the respondent. So again, the Disciplinary Administrator's Office stands by its recommendation for 1-year suspension. Are there any questions?
I did have a question, perhaps best answered by the respondent and counsel. Is he still a municipal court judge?
Yes.
In Cimarron, Ingalls?
Dodge City.
In Dodge City. All right, thank you.
Thank you.
I thank all counsel for your arguments this morning. Court will take this matter under advisement.